Criminal barrister Margaret Cunneen SC is the guest and star of this episode of Elephant in the Courtroom. She speaks about her 40 years of experience at both ends of the bar table, covering everything from death threats, sexual assault, including the highly publicised trial of Bilal Skaf, and why she called her book, The Boxing Butterfly, A Life of Conviction.
Welcome to Elephant in the Courtroom. My name's Nick Hogan. I'm a barrister at the New South Wales Bar, and sitting beside me here is my good friend Awais, Ahmad. He does likewise. We're a couple of barristers who like to look behind the routine appearance of the law. So we want to share with you a few little hidden gems going on in courtrooms, some first-hand insights from those who play a role in it, and other things, topical things, experiences, stuff we think you might find interesting. Sometimes we'll get serious, maybe even a little deep, fussy.
Loved it.
And other times we'll keep it nice and light. But at all times we'll try hard not to undermine your confidence in the rule of law. It's funny, Vasi, how are you?
I'm well. Yeah,
Back again?
Back again. It's great to be back.
It's funny just that last comment about undermining the audience's confidence in the rule of law. I mean, it's a big concept, the rule of law, isn't it, really? I mean,
it is, but it just sort of, it's a big concept, but it encapsulates so much of what we do and why we do. And I suppose when we were brainstorming this show, the balance that we were trying to get to is, well, let's not by design just expose all of our abilities to undermine it. But
yeah, I mean, it's a bold statement to think that we could even undermine or have any effect on such a foundational principle.
We're participants, but at the end of the day, we're a couple of elephants, and anything could happen. Nick, look, it's great to be back here. Yeah. It's great to be back here at the Wesley Mission Conference Centre, supporting all the great work that they do.
Yeah.
We're really, truly lucky to be here. We've got a fantastic show. I'm very excited about it. As you know, we've been talking about it for a little while. We've got an absolute delightful guest today, Margaret Cunneen SC, or as I like to refer to her as MCSC.
We'll find out if she likes to be referred to that way.
Well, I suspect she might anyway, because she's also known as the Boxing Butterfly. And that comes from her book that came out. And in fact, I bought a copy, of course. Here it is.
Oh, and did it come that way, or did
no? Well, as a true barrister, I've flagged it up with a bunch
with a whole bunch of notes, and now you don't know what any of them refer to, and you're just hoping that
fluorescent tabs. And I always write. I always do this. I write so fast and so quickly, and I can't read my own writing.
And the wrong way up, so that you've actually got to turn it around to read the note. Oh, that's where that is.
Do you think at uni they should have put a whole unit to tabbing?
Oh, I don't know. I think everyone's got their own systems.
But you've read this, haven't you?
Oh, I have. I've read a fair bit of it, and it's a good read. I mean,
I couldn't put it down.
Yeah.
What I found interesting about it, and we'll obviously get into the detail about it, is how her passion and conviction and the significance that she's had in law has been balanced so finally between being on the Crown side and then on the defence side. And there's one passage I just want to show you before we get into something else that I thought was really interesting, because it goes to some of the things we want to talk about today. She was obviously a Crown prosecutor for many years.
Oh, 3 decades.
3 decades, yeah. And was obviously quite high up. But then when she came to do defence work, in fact, she represented most notably recently Kirtley Hill, and even Jared Hayne. But there's just this one passage I thought I'd draw out for you. It says, "The biggest lesson I've learnt this year is that when a prosecutor is given a Crown brief, what one gets is a bare scaffold of theories which have been arrived at by investigators. But when you meet the subject of this prosecution, he or she, and I haven't met many she's yet, he can fill you in of all of the texture and all of the explanations, because it as rarely is the case that any aspect of the evidence is all one way." So I just thought that was interesting, that we'll get into, is that she's had all of these convictions on the Crown side and then got this sort of new perspective in defence. But
that's the very reason for the presumption of innocence, because there are two sides to every story, and as I think Margaret expands upon that in the book, the police come at it from obviously a different angle. They formed a view. Obviously, that's why and they're presenting this information. They're gathering it, working towards a case theory about a person's guilt. Obviously, they say there's enough here, but they don't have access to all that information that comes from the defence side. And it's quite a privilege, and it'll be interesting to have someone who's seen both sides and who can talk about that. But that scaffolding image is an interesting one and quite telling. Bussy, how's your week been?
Well, it's been an interesting little bit of period since we last caught up. I did a contravention application in the family court. Have you ever heard of those?
No. What's that?
They're like they are criminal proceedings because the sanctions are criminal and they're punitive. They're criminal proceedings within the family court that a party can bring to allege that a party has not complied with a parenting order, for example. So a parenting order that says child A will spend
the weekend with the father
and
whatever.
Often what happens is it's quite fraught because what might happen is that one child might have a particular aversion to going to the other parent's house that day because, of course, they're developing their own feelings about things as time goes on. And then one parent is put in this invidious position of having to sort of compel them physically or otherwise risk facing a contravention application, which is not only...
Getting to Friday night and saying, Mum, I don't want to go to Dad's this weekend or vice versa.
They're fraught, they're fiddly, they're difficult to run. We had...
what side were you? Which side?
I was the contravenor, as in my client was alleged contravenor, and she her case was no point getting into one aspect of it, but one contravention was as trivial as not taking a FaceTime call, for example. So the court prescribes contact orders for FaceTime calls once a week, and the children weren't coming to the phone on time, etc. And that triggered a contravention. So there we are.
That seems very minor, doesn't it?
And there I was. And I mean, it's also a blessing the way the courts are now structured more uniformly nationally. I think COVID's really brought that apart. I was in Parramatta, believe it or not, appearing before a screen of a judge in Adelaide.
Yeah.
So anyway, that's what I've been doing. Lots of little busy things. What have you been doing? Lots of nuisance cases, it looks like.
Not a lot. It comes up. I've been doing a fair bit of advice work, and that's not obviously as fascinating and dynamic as the court work that when you're doing court work and you've got sort of tales and the colour of the courtroom.
But advice work has its own little charm.
It makes you drill into areas of the law, into particular aspects of the case you're looking at in a very in-depth way. But one thing I was noticing is that, and I've done a number of large advices since the start of the year, it's just the way it's worked out, is that your brain ends up becoming full, like this, like a glass of water. You end up, you reach the top with information, and you start to sort of lose the capacity to recall information that would otherwise be at your fingertips because your brain seems to be so overloaded with information.
Isn't that such a problem at the bar? Like, I mean, at least for me, I'm sure there are plenty of intellectual giants that can handle all the information. But if I've done something,
the elephants have.
The elephants are
who are just roaming about doing their best trying.
Yeah, but we're very forceful in the moment. Yeah. We know everything about. For me, anyway, I know everything about that case. That day, or that conference, but as the days develop and something else comes in my brain, there's an automatic deletion button. I've done cases part heard. This will give my clients great comfort, and I've done them part heard, and I've come back to them, several months later, and I've had to remind myself who I act for. I've had to remind myself. I'm looking back at my transcript. Have you ever done that? Look back at your cross-examination, and I thought to myself, why am I asking these questions?
You wonder whether the judge was thinking that too.
And I remember at the time just going, this is so good. This is so good at the time.
Yeah, I'm just nailing this.
I've nailed this cross, and I am putting on a show for the courtroom. Not that we always put on shows, but I'm doing my job, etc. See, that's a rule of law issue, isn't it? But anyway, coming back to that, and I just go back to the transcript and go, I'm running that, but it's actually... It comes back to you and you eventually work it out, but it takes a lot of time.
But it is, but I just mean in day-to-day affairs with just the names of things and events and timings and stuff of just in your outside law stuff.
Right.
You're just less useful and less sort of even my vocabulary sometimes drops away. I think, I want this word. I think I know there's the word that I'm looking for there. Speaking of which, Margaret Cunneen has an excellent vocabulary. She does some very good words. It is with great pleasure that I get to introduce our guest for today's show. She is a barrister with over 40 years' experience at both ends of the bar table, that is, as a prosecutor and as a defence counsel. She has prosecuted numerous high-profile criminal cases with great success. I did read somewhere that the success rate was in the vicinity of 80%. She's recently written a fabulous book called The Boxing Butterfly, A Life of Conviction. This lady is cool and pleasant, yet fierce and formidable in the courtroom, and there appears nothing that she hasn't done in the criminal law, all whilst maintaining her role as a loving mother and wife. And rumour has it that they have even made a TV show about her. She is, of course, Margaret Cunneen of Senior Counsel. Welcome to the show, Margaret.
Good morning, gents.
Yeah,
Thank you very much for the honour of the invitation.
Oh, it's a pleasure.
Thank you for being here. And there was just on that introduction, there was one passage. We couldn't put this down, and we've already had a bit of a chat about some parts of it this morning.
A lot of notes there.
Well, you know, the fluorescent...
It's like one of my briefs.
The fluorescent pink tabs. There's an anecdote here. From all accounts, Margaret has prosecuted with precision and polite steel, impeccably respectful, and always ready with a genuine smile, even in the face of the most brutal crimes and hardened criminals, and a few haughty judges. She stood her ground amid controversies and stared down her critics. Her convictions, both in the courts and those in her heart, continue to define her career. And in fact, that reminds me, I was a friend of the show, Justice Hamill, made a few comments to pass on to you. He sends you his best wishes, but he also says, she is consistently delightful with my staff and with junior counsel, and quite the formidable jury advocate. She can get an admission from a witness just by pausing and raising an eyebrow. I've seen it happen. A couple of other comments that I'll have to take up with you off
rather
air.
Overwhelmed by praise from those heights.
Indeed. Margaret, the show apparently is Janet King on the ABC. Is that true?
Yes, it is true.
Yeah.
In fact, Crownies was the first show developed with my assistance in this respect. At the time, I was a Crown prosecutor, and Nick Cowdery was the Director of Public Prosecutions, and the production team came to Nick and said, may we follow a Crown prosecutor to court and a woman, and he rang me, and in his office I met Marta Dusseldorp and the producers,
the actress,
and
yes.
and she and I are still very best of friends.
Wow.
And
isn't that great? So they just followed you around for quite some time on cases you were running at that time.
Yes.
Is that the antithesis to Rake, which is loosely based on our dear friend of the show? We will have to get him on one day, Charlie.
yes, we often fight over which show is the better show.
Yeah, right.
And frankly, Rake seems to have more fun than Janet.
Just a fact here. Do you know...
Well, they're sort of opposite ends of the spectrum, aren't they?
Quick fact, interesting point. Do you know that I've appeared on the credits of Janet King?
Have you?
Yes.
What did you do? What was your role?
I was...
You're a consultant to the show?
I was consultant.
With all those jury trials you've run.
Well, there's that. And all those... I want to talk to you about my jury trial experience in a moment, but I was recruited to advise on courtroom staging and acting and what they would be doing. So I went to Parramatta Court over a couple of weekends and sat there, and I remember... just being the elephant in that courtroom again, because there I was in the gallery while Marta Dusseldorp was doing her appearance, and she was at 12 o'clock, I would have been at 5, and in her peripheral she could just see me sitting there and moving around, and she's like, "Can you sit down?" I actually was on the ground in the gallery, just hiding so that she could film. But I made it into a couple of shows.
Oh, that's terrific.
So there she goes.
Yes, she's a wonderful person. I'm sure she was most polite.
Yeah.
We're going to cover a bit about that, obviously about the book today. Interesting that why you called it that, Margaret. Could you comment on that?
Yes, I'd be glad to. Well, I do box for sport, and there was an occasion when, during the ICAC rogue period, one of the a very new commissioner, and a commissioner who very shortly after decided to launch a pretty ill-fated persecution of my family and me. And that commissioner gave a talk to junior barristers or barristers in training, and said to them, if you're sick of adversarial litigation, come and work at ICAC in the inquisitorial system. It's a lot of fun. It's like pulling wings off butterflies.
Oh my goodness!
And you can go wherever you like.
And so you were just slipping.
You felt like the butterfly having its wings.
It was very timely.
Yeah.
And that's how I felt.
I also heard on that and I can relate to this because I have done quite a bit of boxing myself, that you related the art and the sweet science of boxing to being an advocate in court.
It takes a lot of courage, doesn't it? Boxing is maybe one of the most courageous sports because you're on your own. Of course, team sports are great too, and they
You're a Manly supporter, aren't you? Sorry, part of the research. I'm a Roosters supporter. I'm sorry. I know.
Yeah,
what do you say?
That's right. Well, Vegas was fun for everyone.
Indeed.
But yes, I am, and I do think that sport teaches young people and teaches everyone great lessons for life. But it's particularly apposite for court, and even for people going through court as an accused person. There are battles, there are stages, and trials are a bit like a cricket test match because some days are up, some
I've
days
always
down.
said to anyone that's bothered to listen to me, and this is why we have a podcast now, so it's for our 5 guests, is being a barrister is closely related to a boxing match, because I've had 2 fights, and also opening the batting in a cricket game.
Yes.
When the ball is new, you're on your own, all the demons are in your mind, and you're trying to concentrate.
Short pitch stuff.
The short pitch deliveries are sharp questions from judges. And so there's a lot of mental fortitude that one requires, I think, in being an advocate.
We've thought of doing a whole show on sporting analogies, really, and being raised in judgments, but that's for another time. But so life as a prosecutor, you've run so many high-profile cases. I mean, a number of which are referred to in the book in great detail. The salient bits that you wanted to draw out about some of the themes about the human side of running those cases and some of the injustices, etc., that had resulted. Which of those sort of stick out as particularly satisfying, disturbing, or, I mean, you've chosen all of them because they all do, but are there any particular cases where you think it had a big impact on you and you've come back to them in your mind over time since then? They happened?
There was one that I couldn't even write about, but it had such a big impact, and it was the prosecution of someone who was charged with and ultimately he was, after a Court of Criminal Appeal case, he was acquitted. But the case really, and he's at large. Good luck to him. But it was I did the retrial. Mark Tedeschi, who was then my senior Crown prosecutor, did the first trial. And he said that it had come down to cross-examination. And I'm still very proud of the cross-examination that I conducted in that case. There was some elements about it that I think exposed the person very much.
What do you mean about the cross-examination?
It was getting into how cold I thought he was about his family.
Right.
It was interesting because I was the prosecutor, of course. Defence counsel didn't have any children and was an only child. The judge didn't have any children and was an only child. But I think many of the jurors knew more about families, and they were moved by that. But some people would think that may be a female way of looking at things. And I think that at that time, which is quite a long time ago now, 16 years ago, both the judge and defence counsel thought, well, what's this got to do with the evidence?
So a female way of looking at things, is that to suggest that you had some extra power to detect
Sometimes,
motive, or
sometimes.
what do you think that was getting at?
Well, you first of all, you have to think why. How could someone kill people?
Yeah.
Maybe because they don't care about them. Maybe they hate them.
It has to be the case at one level, doesn't it?
Yes, and so you look for things that might be different in this family.
It seemed perfectly,
or different in this person.
Seems like a perfectly reasonable line.
Yes, and that's right.
Saying,
and probably what was traditionally thought to be males and females' lines of inquiry have converged much more, because it must be said, mustn't it, that men are allowed to be a lot more human. Gosh, look at what's changed. It's everyone congratulates men on going home. Yes, and I've got to go home and look after my kids or pick up my kids.
Yeah.
Gosh, when I first had children, I didn't dare mention them because that would be regarded as not important.
So in that context, you're talking about the vulnerability that sits with a man in the accused. But did you experience having to tailor your advocacy differently because you're a woman? Is that
well? I didn't do it.
Yeah.
And
initially,
initially,
how did you experience it? Yeah.
Initially, it was probably thought to be a little unscientific or something like that, or irrelevant,
lacking in relevance. Yeah. Oh well, that's just not relevant. But you're bringing a side of an intuitive side to the case, which is persuasive. Obviously not on a specific fact in issue, which is obviously the way a lot of judges view and other advocates view things. It has to be drawn back to that. And of course there has to be that standard. But what you're saying is you're bringing in a bigger picture, because you're creating a concept of this person for the jury, such that it makes it more likely that what you say is what you contend is in fact true.
Yes, that if you're looking if there's no other motive but hate, you've got to uncover it. Hate or complete nonchalance, or a complete lack of empathy, which can make a psychopath.
Yeah, it's interesting, and so you found that sort of haunting or frustrating in a way that the judge and you couldn't see it in that way.
Yes, but I felt the jury could.
Yeah, and well, that's the main thing, course, isn't it?
Yes.
Right, and it's not written about in the book.
This is the thing about crime.
Yeah.
It's really mostly about life and people, and we have rigid laws to regulate what we do. But ultimately, the fascination about crime is that it's about people and doing things, or people finding themselves in the most horrible circumstances, whether they're the accused or the victim. It's horrible.
When you get a case, is that sort of where your mind goes in the beginning is, well, I think you already answered this question, why would that person have done that? Why could that person? Because an ordinary person just would never do such a thing. Is that where you go?
Yes.
You go right there first and work backwards? And how can
a jury, if there's evidence there, you've also got to convince a jury that it could happen. And well, that was very much the case with child sexual assault that I really started in crime doing in the mid-1980s, at a time when many people in the community would not believe that men would do such things, mainly men,
I read
to
that
children.
You wrote that was in the Dolly Dunn trial.
Yes.
You had some resistance to even play the videos that he'd recorded.
Yes, the judge resisted it. And didn't want to look at it, and said, why can't you just put up a statement of facts? And every frame was 1,000 words or more. It was something that, as terrible as it is, and as much as it stays in your mind in a shocking way, really, some judges and the public had to be shown how in his case the victims, and they were clearly victims, were used to what was going to happen. So he could convince himself that they consented or perhaps even enjoyed it.
Yeah.
Because they were so used to it, and they got rewards at the end, but they were 7 or 9.
Shocking.
And just on that, do you mind if I ask this, Nick? The horrors of the work that you do, and you describe it that way. Recently, there's been a lot of conversation about workplace trauma, and even there's been some discussions in the committee I sit on about the possibility of considering amendments to the bar rules to have be able to refuse briefs on the basis of perhaps workplace trauma. How did you deal with it? Do you have anything to say about that? How do you still sit here today?
I've probably got a lot to say about it, because there have been times that my heart and soul have been wrenched by just complete dispiriting demoralisation when you think that something goes wrong. And that's more the case as a defence counsel than as a prosecutor in a way. Right. Because and I've seen it happen, it's a sliding doors moment, guilty or not guilty. It can be jubilation, or it can be absolutely almost the worst thing that can ever happen to someone.
See, I found that fascinating when I started going to the bar, when I came to the bar at 26 and didn't have much of life experience before that. And I fell into crime pretty quickly, because in the early days...
Doing criminal cases, that is.
Yeah, well, taking criminal briefs. And one thing that stayed with me, it still does, is the congratulations I would give my colleagues at the bar for, well done, you secured an acquittal, congratulations. And then I also had some colleagues doing prosecutions. Oh, did you get your conviction? You know, and I just found it odd that you sort of
the win-win, and in a way,
the mentality.
You're congratulating them because you know they've worked hard on a case,
done a good job, not for the result itself and the effect that brings.
I think that's an important point to discern in your mind, right?
It's a very important distinction. Yeah. If you also think that the justice has happened, and that's been very important to me too, and it still is, and it really still is, and so both things matter. But it's interesting that you mention about winning and losing, because I worked at the DPP since before it was the DPP, and so I was there when Reg Blanche came to the helm and taught us all so much good about being a prosecutor, because he had been a barrister he'd been a public defender, he'd done defence, he'd prosecuted. And he and Nick Cowdery, when he came to and continued this, there was no win or loss, really. There was a fine job done, but there wasn't to be a win or a loss. There was justice being done. And we were very discouraged from going to celebrate someone going to prison. It was just justice being done, and we represented the whole community, including the accused person, and that was very much emphasised. And I fear that may have been lost a little in recent times.
And is that interesting? Yeah, that's such an interesting point, because obviously, what we as barristers understand, but our audience may not necessarily, is that there are prosecutorial duties that govern the way you are meant to conduct yourself. You're meant to lay up the evidence in a fair manner.
Yes.
And your goal is not to secure a conviction, but to promote a fair trial or present the evidence in a fair manner.
Yes.
And I often thought that might be an easier way to live, because
it is.
You can,
but also that you're performing a service to the public, really, aren't you?
Yes, every member of the public.
You are truly a public servant in the, literal...
And I took that very seriously because I joined public service as a school leaver to help people.
What do you think's driving advocates now who are appearing in that form to perhaps take it more personally, or perhaps try and secure wins versus that original, more fundamental culture you speak of?
Yeah. Perhaps they didn't learn from Reg Blanche and Nick Cowdery, and I didn't hear. I was there after Mr. Cowdery retired. I wasn't there for the current regime, but there seemed to be a shift even then. I quipped not long before I retired from the public service, turning 60 in early 2019, that I had, as a Deputy Senior Crown Prosecutor, as I then was, I had fewer delegations than I had had under Reg Blanche as a senior solicitor in my late 20s. So less discretion had been taken away. Of course, it was a much bigger operation, and Reg and Nick knew us all very well. And if I picked up a brief and you could see some real credit issues that you'd know would come against you, you could see the accused was a person with an unblemished character who would have the benefit of good character directions, and all these problems with the credibility of say a complainant, you'd say to I would say to Nick Cowdery, this has got problems, and you'd say, if you can't win it, no further proceedings. You didn't have to write a thesis about it. Whereas not long before I retired, there was a homicide case, and it was clear that it was a woman, friends, a dead lady and a dead friend who the police thought may have put a pillow on her face, but she was known to put pillows on her own face, drugs and all kinds of things, older people. And I thought there could be no prospect of conviction at all. And but I had to write a very, very long submission. And I put that up, and it goes through a lot of channels without undue modesty or immodesty. People that probably had very little trial experience, and I waited, and then finally I got the response, no, it wasn't going to proceed. And I rang my instructing solicitor, a young person, 20s, and I said, the director has decided not to proceed. Oh, I know. They were on the phone checking every line of the submission with me. And you think, what do they think I'm trying to get out of work or something?
Wow.
That had never happened. So there has to be a degree of trust in very, very, very experienced trial lawyers, and something that the first two directors used to emphasise was we were independent barristers. We were proper barristers. In the same way as other barristers were, except that we were employed by the government. But there was a separation, as there should be, between the instructing solicitors and the barristers. And the barristers have an obligation not to prosecute people that they don't fully believe deserve to be prosecuted. You might know the answer for sure. Who can, because trials are so good at getting the truth out.
Well, I wanted
because of the risks associated with it, needs to be very carefully considered, obviously.
Yes. In the Anthony Richard Dent trial, the triple murder, I wanted to take you to that for a moment. Andrew Richard Dent, you say, as recorded in the book, that it wasn't his first time when he entered the dock. In the 1970s, when he was 17, he had been sentenced to life imprisonment for bashing two men to death in separate incidents. For reasons of legislative reform, he got released after 15 years. At 55, Dent was on trial for the murder of Tony O'Grady, who was left bashed and hog-tied with his underpants torn off and stuffed into his mouth. You were Crown Prosecutor when Dent was arraigned with his young accomplices, and you were cross-examining him. During his arraignment, he went so far as leaning over to you and saying, "Are you fucking serious or what? Oh, fuck this shit. It's all fucking nonsense. It was 40 years ago. The judge expressed the intention of having him removed. Fuck you, Dent thundered. If you ever look at me like that again, I'll come up there and rip your fucking face off. You heard me."
Margaret, before we leave, if we do leave that case, I wanted to ask you something particularly about that. Can you firstly tell me what a Kubertan is?
Oh, yeah.
What does it look like? And what do you use it for? No, we'll get to that. Just tell me what a Kubertan is.
A Kubertan is a metal rod, and sometimes it has a pointed end, not sharp but pointed, and sometimes they have a hole at the handle end, through which one can put.
How would you hold it and use it?
Hold it with.
It's a martial arts weapon, isn't it?
It is, and it may be a prohibited weapon, but how long ago is this?
We won't touch on that. No. It did occur to me, and I thought, but no, it doesn't matter. I mean, it's all in the past, but...
yes, it's about...
we give 1 to 8s here every day.
Yeah, we'll give you a 1 to 8 on this.
About 15 centimetres long and about a diameter of about 2 centimetres, a solid metal object. And it can be held either way in the operative fist, but I like to hold mine with the pointy end out of the end of my fist like this, because I find this striking action pretty good.
Well, this is good to know that that's how one might use it. And you were also, obviously, and this is well known, you were a 4th Dan in Taekwondo.
Oh, that's
Your
right, yes.
partner, Greg, is a 9th Dan, which I understand is a Grand Master.
He's a Grand
Master.
Master.
Can't go any higher than that. He has his own martial arts academy.
You've done your homework.
Well, look, these are fascinating tidbits. So the Kubotan is a martial arts weapon, obviously. And it fits neatly in a bar jacket, doesn't it?
It does.
Apparently, alongside highlighter pens and other things.
Half a sandwich,
post-it notes, and a half a sandwich one might keep in there. And in a serious criminal trial, the likes of Mr. Dent, you would apparently, just to give you a hypothetical. So you were cross-examining Mr. Dent. He had already he told you that he was a very violent man, and obviously from the things that have been quoted there, he clearly was he was a man with intent and hatred and all the wrong ingredients. You're cross-examining him. You're obviously not very far away from him.
Yes, and the custodians, the correctives officers, there wasn't one there who was less than 100 years old.
Yeah, right.
So this informed the reason for the Kubotan, because you thought. And were you practicing Taekwondo back then?
Yeah. Oh,
were
yes.
you as competent as you are now, or as down the track?
No, we always get better.
But you were pretty competent. If somebody came for you, you could have handled yourself to a degree.
Probably not, but at least I can try.
So if Mr. Dent had decided that you'd landed one too many blows, and it sounds like in the cross-examination you did land many.
Metaphorical blows.
Yeah. But blows, exactly. Probably a poor choice of words. And he, because you weren't very far, hypothetically, had lunged towards you from the witness box. What would you have done having had a Kubotan in your pocket? What did you have? Did you play that out in your mind back then?
Yes, I did.
What you might have had to
do? Not for the first time.
Do?
And I would have picked it straight up from my bar jacket and just gone for his nose.
Right.
To move him away, because it quickly
do anything I could.
It wouldn't have meant he would have been something that happened to him super serious, just enough to get him away from you, so you could make its way to the courtroom.
And so,
that's what you were thinking, weren't you?
So who would you assume then that? Here we
self-defense.
go. Here we go. Let's assume that we've got some. I think as the words described in the book as a professional enemy. Let's assume a professional enemy comes around and charges you. Who do you call as your defence counsel?
Wow, it's difficult, isn't it?
Well, you can have a team.
It depends.
I'll give you 2 leaders and 2 juniors.
So, is this a physical altercation, or is this?
No. Well, she's defended herself over
Mr. Dent
during her cross-examination. Yeah. A professional enemy has decided to charge her with an assault or a violent GBH, reckless wound, whatever the words are these days for these charges, and you're now charged.
Phil Bolton.
Who's
Phil Bolton and Claire O'Neill.
Oh, beautiful. Okay,
that's a great advertisement, isn't it? I think you're not the only one who thinks that about Mr. Bolton. But there must have been times when, like that you felt danger in the courtroom. Did you ever feel it outside when you were running a case and someone might have a word got to you that particular accused or whatever is thinking I'm going to get you or
Definitely.
whatever.
In fact, I even had a call. I've had death threats. I've had a call once from. We know you drive a yellow Mustang and that you stop at Palmer Street, turning left into Oxford Street at the same time.
Don't give too much information away.
Every morning. I had to sell my yellow Mustang, but legal fees. But that's another story. But I said, well, if you know this, why haven't you effing shot me yet?
Wow.
F off.
Is that what you said?
That is steel.
Wow.
That is precision and steel.
Like it.
And do you and is that sort of fear come from people who are currently before the system, or do you think that people who come out after their sentence that they might seek retribution? Or
I thought it was a lawyer.
Yeah,
I imagine, I mean, there was some of them I mentioned in your book, obviously a bit disgruntled convicted persons will make complaints to, the Legal Services Commission and all that sort of stuff. That must be so annoying, and you've worked so hard to secure a conviction and everything, and then there's this hangover from the case where hopefully not too often, but you have to meet these
I had it so often, and I
Yeah.
do think, and in fact I know it's true, that they were sometimes encouraged by their legal representatives, because Charlie Waterstreet told me, and may have done it, to put in complaints when when more trials were coming or retrials or whatever, to distract me.
Yeah, right.
Because it's very distracting, and it takes a lot of time, and no one else can really do it. So they might say, we'll give you a counsel or something. You've got to be the one to write the stuff.
You might need to review transcript and do really detailed things like that if there's a suggestion. Because the Court of Appeal a couple of times picked you up on putting certain things about one case about asking. It was a case involving something that allegedly, it was the genesis of it was at the Exchange Hotel in Oxford Street. And there was some questioning about the sort of things that person had engaged in the toilets, and people generally do in the toilets at the Exchange Hotel.
Yeah, that was his case.
Well, exactly. Yeah. And you were later in the Court of Appeal. It was said that you inappropriately, again in that same way that the story you told before, the judge said, "Oh, well, why are you asking this?" It was you putting the full picture together for the jury. Is that something that also frustrated you?
Very frustrating, but vindicated in the end. In fact, I was criticised for even postulating some theories of how the homicide took place, and I'd put them in during cross-examination. I had put them, so I was permitted to, I was able to do it. I still think I was. The court of a judge criticised me for speculative speculation. However, as it happened, the guy later pleaded guilty. It was true. It was all right. It was all true.
Yeah.
It was so. Anyway, but this is times. It can be very frustrating at times when you know that you're right, and you have to go through a few. In the end, years later, vindication does come.
Is that a function of sort of interesting theme of some broader emotional intelligence that I'm detecting that maybe is really shining through in a lot of your cases and the way you approach things, that you sort of bring an all-round package of understandings and insight into the human condition that then leads you to do certain things where people with blinkers on kind of shut you down a bit?
Maybe I am lucky about that.
Yeah.
But I've always loved people, all kinds of people. And sometimes I've even been criticised at various times. Or how would she know him? Or how would she know a tow truck driver? Well, because I drink down the pub with my sons, one of whom's in the automotive industry. What's wrong with that?
Yeah.
I'm just a normal person.
You like hanging out with non-lawyers, don't you?
Well, yeah.
Yeah.
Yes, please.
Yeah. Not necessarily any sort of great preferential thing. You just find that you hang around with a lot of non-lawyers.
I have a few friends who happen to be lawyers, but more friends who aren't, and that's healthy, because look at all the other things you've got to know in trials. It's no use just knowing lawyers and the law. There's lots of other things you've got
how to
know.
relate to people.
And so I do really like people. I catch the bus to work, and I really like doing that, and do shop and do all the ordinary things.
Yeah. We saw. I read something along the way when sort of looking into this interview, is that you didn't consider yourself part of the establishment circles or the circles of the bar in your early days, or perhaps ever. Do you get a comment on a bit of that experience?
Yes. I never really felt, but maybe it's that imposter syndrome that
we've all got
maybe
that.
We've all got it.
Yeah.
But I really had it, and I didn't I didn't think I was as smart as everyone else, and the public service too. I'd started in the public service. I had only done law at night. I did bachelor's degree and master's at night. Not because I didn't get a high pass, but I just didn't have the backing, the personal backing at the time, and I had to work full time to be able to do it. But that spurred me on to study very hard. But I didn't have, I was with older people in my part-time courses, so I didn't have a cohort of people, and I was in the public service with people who weren't lawyers and who had dropped out of law and for the first 5 years or so, and then going to the DPP later. I had friends there too among the solicitors, but I just had a different path from many other people, and probably being in a relationship with someone who wasn't a lawyer too. That led me to other people, and so. But I think that's been very healthy. I think I know a lot more about life than many lawyers I meet.
But that's sort of that was the beginning, I suppose, of perhaps your feeling it, or not even if you consciously felt it at the time, that I'm not part of this Phillip Street or the whatever it is that the establishment is in the New South Wales Bar or wherever that could be found. But it appears over the course of your career you've sort of sometimes in what appears to be a forced situation, because these things have been brought upon you to sort of rail against the establishment, if you like, or the powers that be, or I don't know if I'm using the right terms there, but
I've had to fight sometimes. I'm so surprised. It really surprises me.
Quite a lot, though.
Quite a lot.
Yeah.
Quite a lot. And so many people said to me, "Oh, a lot of people hate you." And I say, "Have they met me?" And so often they say no. Yeah. And I say, "What have I done?" Do they tell you why? And they just hate me on spec.
Well, we as elephants tend to understand that.
Do you think that it's also because you're not afraid to be outspoken and on certain issues, and if you feel strongly about something that you've got is in your bailiwick to comment about, for example, sexual assault trials and the like, and consent and things. I know you've spoken out against that, and obviously against public hearings in bodies the likes of ICAC. Is that also, do you think, because do you feel that there's a sort of responsibility to speak out?
Yes, I do.
Things?
And if you stand for something, you've got to stand for it and keep standing for it. Not waxing and waning or not having a view. Yeah. But it started because of the terrific career I've had, because Reg and Nick used to get me, because I did so much child sexual assault that was so much in the news in the 80s and 90s, they'd always get me, and the relevant Attorney General would get me to speak about it, to say what measures we were doing to assist complainants in trials. So I'd go on TV to talk about that. I was told to do that. I was the face of the DPP in those days, and they didn't want to do it, or they didn't know enough about it. And they wanted to present that good, positive face of measures being instituted and followed through, and friendly, good people to help kids through the journey. And so I and then Nick used to often get me to do interviews about various aspects.
You've been on TV though, and all around the place, having spoken out about things, obviously given many lectures. I thought it was interesting that you had it's very well documented, the ICAC episode, and you were investigated there and ultimately have to take things to the High Court to clear your name.
Well, I didn't take it to the High Court.
Well, they did. They did. My apologies. That's right. You are correct.
On jurisdiction, wasn't it? Yeah. And then sometime, what I thought interesting was some 2 or 3 years later, you were then asked to be on a panel for when the consideration of a national body, the likes of ICAC, was to consideration of that being put into place. Did you find that sort of an interesting sort of irony that you had sort of had this experience with ICAC, and then was there anything? Well,
I suppose I'd learned a lot about such a body.
Indeed, yeah, and maybe you were.
where things can go wrong, because not only the High Court was about jurisdiction and the Court of Appeal, but people forget that the ICAC inspector, Justice Levine, had a look at all of this and said it was unjust. It didn't happen.
Yeah.
It was unjust. It was oppressive, and there was no truth in it. And because the whole premise was wrong.
It's so sad
because she had been blood tested.
I was going to get into that.
And I wasn't there, and neither was my son.
And so the complaint, look, it's a shame that we have to talk about it, because and it's a shame for you, because this was an utter witch hunt. And again,
it was terrible.
Professional enemy is why I used that phrase earlier. Where there's some assertion that you gave some explanation at the scene of an accident to fake chest pains, when firstly you weren't at the scene of the accident. Secondly, there was no blood alcohol concentration of any concern, and
there was nothing.
Thirdly, it's not even got remotely anything to do with ICAC's purported domain. So it was a complete witch hunt. But there was no communication between me and the driver, and my son wasn't there either.
Yeah.
And I think that's evident. But my question is why this must have been lesson's the wrong word, but you might have given you understanding to how easily reputations can be blemished by sensationalist media, and you still, to this day, we were interested to ask you about it, but still are talking about it because it sits there amongst all of your very many wonderful accomplishments.
Yes, it does. But look what it did for me. It made me see that people can be falsely accused. And what a great lesson for a career prosecutor. And it gave me the right degree of scepticism about everything you hear.
Can I ask you about that? Because in your book, and I read this passage out earlier because it was just, it stayed with me immediately. It's early on in the book where you talk about this new perspective you got when you came to the defence side, that prior to being in the Crown side, everything was presented as a scaffold of evidence and documents, but by speaking to a potential accused, you had these textual layered implications that gave colour to all of this scaffolding, and it changed your insight. Now, is that something that only really came to you when you joined the defence side?
Yes, it is. Yes, it is.
And is that something that needs to be addressed, maybe perhaps to those who are consistently seeing it through the prism of the detectives that hand up the briefs to the prosecutors? Is that?
Maybe it is, or maybe they can learn it from my experience. But I was wondering, will I be able to do this? Because most people are guilty and they're all terrible people. Well, I found a lot of my clients were not guilty at all and have been proven to be not guilty. And not just in sexual cases, murder too, the most important case I've ever done. So not everyone's guilty at all. Not only that, nearly everyone has something, some redeeming features. And so I found myself with almost all the clients I've had, almost all, but not all, really feeling for them, understanding them, and they become like the victim or complainant was when I was a prosecutor. And I was always accused of getting too close to those people or their parents if it was a murder case and the victim was dead. I'd get very close to those people because I'd want someone to be close to me if I was going through that. But now I do it for the people that come in. And after one hour's conference with a new client, I generally give them a hug because I feel sad for them.
But is that the problem, Margaret? Like we've been sort of talking about like some of the sort of frustrations that you might have experienced at the bar that's traditionally conservative, that you have this empathetic approach, this well-rounded ability to be a human as well as an advocate. And when you were a Crown prosecutor, you thought, well, my role is not just to lay this evidence up, it is to do a service to the community, protect the victims, be their support person, be their anchor, because there's no one else going to do it. So, and then in the case of defence counsel, well, you've got a story to tell, that everyone's got a story to hear. And I wonder if that empathetic approach has landed you into trouble or hot water because of this, again, I call it a blinkered approach.
Yes, well, maybe it has. Bad luck. I'm so glad it's happened that way, because I'm a much better advocate if I get to hear the stories. There are some people. There used to be Crown prosecutors like this. No, I don't meet the complainant. I don't meet the witnesses beforehand. It's not right. And they were coming from what they considered to be a principled approach. But you get so much more from whatever side you're on from saying, did this really happen? That sounds a bit odd. And then there might be an explanation that puts it into context.
We've all had that in a case, though, where you've just assumed that that's patent, that is what it is, and then somebody says something and it totally opens your eyes to it.
Oh, well, they're justified in doing
so
whatever.
Doesn't this go to the fundamental aspect of the why you do what you do, is you do it because you're helping people?
Yeah, that's it.
People talk about it all the time now with whatever job you're doing, is you've got to know really why you do it. Some people go to work for their families, right? I mean, obviously you would do that, you're doing that too, but ultimately in your day-to-day, you've seen that you have the opportunity to help people who are in the most distressing, worst situations that are conceivable. And you feel there that not only is it your job to help them by running their case in an extremely competent way, but also to help them in those other areas because you bring that side of yourself.
That's definitely what I do. And in fact, sometimes I fear if some of the legal principles are just making my brain hurt, that I'm probably a better social worker than a lawyer. But
well, absolutely. I think legal principles make all of our brains hurt.
I don't think you can ever divorce our discipline from the social context it sits in.
Yes,
and
especially crime.
Especially crime.
When it's not just moving money from one so and so to another so and so.
Yeah.
But when it's about
in my family law practice, obviously, it's almost perhaps too much social, too much therapeutic work, not enough legal work. When I was reading and glancing over this book, I noticed that you had included a lot of successful convictions and lots of successful acquittals, coming from a man that's 0 from 3 in 3 jury trials. Have you ever lost a case? And were you going to put some of them in the book?
Yeah, I've lost. Yes, not so much as a prosecutor. No. Yeah. No, really.
You didn't lose many as a prosecutor. None come to mind.
And one of the reasons for that is I didn't run them if they were because I'd put them up and say this can't succeed in it, or it's so what's the use of doing it? We might be suspicious, but suspicion is no substitute for proof beyond reasonable doubt. We can't succeed in that use to. So that's why that helps, doesn't it? But I've lost some cases in the last few years. Yes, and my heart is very aggrieved by some of them, although one of them it's not. So that people don't think I've completely changed, that because it's not just me who's changed. Can I say that when I was a prosecutor doing, when we talk about the sexual assault cases, they were generally speaking, I don't want to offend anyone, but they were much more shocking than the run of sexual assault cases now, which are so often about a romantic liaison gone wrong.
Talking particularly about the date rape.
The date
cases.
rapes. There's so many of them. Well, put it this way: the woman is with the man voluntarily, just with them, and sometimes they've even had sex, and the first three are okay, and the fourth one isn't, and things like that. So that's not as shocking as the rape cases that I did so many of strangers, of violence, terrible violence.
Yeah, you did the Scaf Trial, so it's probably an opportune time to talk about sexual assault and your perspective at both ends of the bar table. You did the Scaf Trials, which is most people would remember as being a very tension-filled time in Sydney or in Australia, especially. It was race relations were pretty tense. Dare I say? I recall that it was in the post 9/11 world. There was the men that were involved in the rape were Lebanese Muslims.
It's around the time of the Olympics, wasn't it?
Yeah, 2000, just before, weeks before the Olympics.
The trial, I think, was in the I think by the time it all
the
went
trials
on,
were 2002.
Yeah, 2002. So the post sort of 9/11 world, the war on terror,
Yes.
Islamic Christian Australian tensions were high around that, and I just put that as context because I, as someone who identifies as Islamic, remembers the sort of change in culture that I experienced. I should say, as being an Islamic person or identifying as Islamic in that time, and so that was something I really watched with interest at the time because it was such a horrifying set of circumstances, but the race relations around it was really interesting. But that's just I guess a side topic we could talk about for hours. But in that trial, that it was so horrific the way in which this poor complainant was the victim was dealt with. I think you say in the book that it became a model for reform in some ways, and it really changed the landscape to protect complainants. Is that fair?
It was a model for investigation too, because it was the first case other than homicide which had used mobile phone data, and that was really strong evidence supporting. And there was more than one complainant. There were quite a few.
Did Bilal Skaf or Mohammed Skaf, one of them, took the mobile phone of the victim in that case because she had a mobile phone ring. An Eminem song or something.
Yeah, the real Slim Shady.
That he liked, and put the SIM card in his own phone, and that enabled him to
put his SIM card in that phone and called.
Put her SIM card in his own phone because he liked the mobile.
He put his SIM card into her phone.
His SIM card.
Made some calls.
Phone. Yeah.
And so the SIM card and the phone each sent messages, but about the same call.
And that assisted with sort of locating him at given
not
time.
only locating him, but meaning
putting
that
the phone
was
in his
there.
hand.
And so it made it difficult to accept his denials of anything. But I know what you're saying there of us about the racial aspects. Yeah. It wouldn't have even come up probably unless they had used those terms themselves.
They brought it upon themselves.
They brought it up.
The way I don't want to use the words they were saying, even though I'm happy to swear, but it was absolutely derogatory way, and also made reference to her Australian nationality. So there was.
She was Indigenous though, wasn't she?
She was.
Yeah.
She was. The main one, the one that had the longest ordeal of 6 hours and the most rapists and 25 counts. 25.
Just shocking facts.
Shocking facts.
So you were doing. I mean, you did that case, and obviously you were abused by people all through it because, as I said, race relations were high, and probably both sides you were getting a bit of flack. But you did that case. You did so many other sexual assault cases for the Crown, and I think in that case, the late Judge Cunneen. He gave an extraordinary.
It was
sentence.
Terrible, and at the time I thought that's. I said to my solicitor, that's bullshit, whatever. Probably stronger. That's just ridiculous. It's not worse than murder. It can't be worse than murder, and we can't be saying it's worse than murder because that gives no hope.
They got 55 years.
One did on the top, that was reduced, but not appreciably, a fair bit, but still it was still really high.
Can I ask you something about that case? It just occurred to me about the attitudes of a sentencing judge. As I understand it, they were misbehaving in the dock, and they were 17 or 18. I'm not, of course, trying to excuse them, but just putting the understanding hat on for a moment, because that's our job and trained to do. Moral culpability, I mean, of a 17, 18-year-old, I know that they're criminally responsible and it's all shocking, etc. But the fact that they didn't even perceive the seriousness of what they were doing throughout their time during the trial and didn't display remorse, was there any lack of cognition there or something?
They really weren't extremely bright. I'd say that I hope it's not disrespectful in any way, but to anyone. But when they were examined by psychologists, their IQs were so low, and they really hadn't had much of a benefit of schooling, and so I even when I was still a Crown prosecutor and Mohammed Skaf was coming up for parole, and I was asked, well, how do you feel about that? And I said,
I was going to ask you about that. You
I said, he's got to get out. He's been in there more than half his life, and he was only 16.
And why is that, again, did you say that? Why did you support his because that was reasonably
Because he got a massive sentence.
Yeah.
And he was so young, and he was led by his brother anyway. And how long are you supposed to do for this? Come on, get it in perspective. It's not murder. It's not as bad as murder.
That's something I think the public struggle with in terms of grading certain crimes in their own mind and thinking, well, look, you know, this, in my view, is just the worst thing that could ever happen. But obviously there has to be not a hierarchy, that's the wrong word, but a sort of a scale for...
But the public, you're right, but the public sort of hysteria about anything these days is so persuasive. I mean, I'm completely off topic, but just another example that's been a function of public hysteria is being the concept that because of the recent decision of the High Court that basically challenged the lawfulness of indefinite detention for persons who have been convicted and their visas have been cancelled and they have nowhere else to go. There's this hysteria that out on the streets are a bunch of criminal, depraved monsters running around. But that's not having regard to, for example, the fact that they've actually served their sentence. They've been criminal. They've been absolutely gone through the criminal justice system, and now this is an executive function about character and whether or not they should stay in detention or not. And that has itself, topically, recently brought about a raft of legislative amendments trying to get them back in, put them under monitoring. I just raise that as something that just occurred to me as being another bit of hysteria. And so the hysteria about that was probably rightfully the way it was. But 25 years later or whatever it is later, on parole, there'll be another front page on the Telegraph when Mohammed Scaf comes up for parole in 5 years or
he's
whatever.
out now.
But his brother's still
but his brother will. He's the last one left.
So the last one left. There'll be another big
hysteria, and people will be saying, but he was only 18 as well. And
do you think the public, and this, we're calling it hysteria or whatever, but the sort of public pleasing is informing any of the attitudes these days to some of these date rape cases and the like? Or is,
yes.
How is that, do you think, playing into this issue of prosecutorial discretion, etc., that I think you've referred to it elsewhere? Just can you comment on that on your views?
Yes. Firstly, a moral failing or leaving someone unhappy about some sexual incident is not necessarily a crime. We've got to remember that these are criminal courts, and rape or sexual intercourse without consent is and has traditionally been the very worst crime below murder in the criminal calendar. And this is something that people and complainants don't seem to understand even by the time they get to court. There are three elements: the sexual act, the lack of consent. That's two things. But there's the third thing. There's got to be knowledge, some degree of knowledge, however it might be graded, recklessness and so on. There's the third element. And so it's so many people don't understand, jurors don't understand until they're told, it's not enough to have the sex act and the woman saying, I didn't consent, and that's the end of it. If the man doesn't know about that, or nothing's been mentioned about that, or the mind's been changed during the night, but he hasn't been told, then it's not a crime because he hasn't got the mental element. I don't want to be mistaken for thinking, just because you drunk anything, people are entitled to do anything to you. I don't think that at all. And I'm very familiar with drinking a lot, believe me, as everyone knows me. But from that, I know, and many of us do. You may not know this of us, but when you drink a lot, see, you can be operating in a fairly normal way and having conversations that you don't remember the next day.
I'm like any good Muslim. I have a selected application of which bits I draw. And what I find interesting about that proposition, because there was the reforms in 2021 about informed consent, and there was a move to make it make there be some proactive step.
Words or action.
Words or action. Can you just explain that?
Yes,
better for me?
it has to be. You have to be able to point to what steps were taken.
Is that part of positive onus on the defence, though?
It really looks like that.
Well, firstly, they probably always have to give evidence to illustrate the positive steps, don't they? When ordinarily a defendant doesn't have to give evidence and often doesn't.
Yes.
I mean, I'm sorry, I'm speaking over you.
But that's right. What steps were taken? Which it's weaselly words for legislation, but but it needn't quite be words. But it's pretty much pointing. It's trying to educate the public that there must always be a conversation, I suppose. But that won't solve every problem because because as we know, a lot of cases have a number of counts, and a lot of cases are I was consenting to a certain point but not consenting after. So there's got to be a conversation between every different act, it seems.
That's tricky, isn't it?
But the accused can point to some other indication, perhaps. But as we know, it can be a look or,
Well, that's the subtleties of romance. I mean, I don't want to say that rape and romance are anywhere overlapping, but obviously human interactions are subtle. And then when you throw alcohol into the mix, it even clouds further.
Judgment can be impaired. And as you say, you could have had 3 consensual acts and the 4th one may not have been. And
there's a lot of these cases too about sleeping, and people say, well, I think I was asleep, and so how could I have consented?
And in the Martinez case...
hard, fast rules are very difficult to impose, I guess, is what you're suggesting, are you? Because
and
every
beyond
case
reasonable
has to be
doubt
looked at.
is a very high bar. And so we're told, believe all women. And this is what everyone in the community are told. And maybe that's a great thing if you're a parent or a sister or brother or a patient tells you something or your friend. Believe them, okay, you believe them and support them. But a jury can't act like that because a jury has to act judicially and they have to put that aside. And if the mantra is believe all women, then that means that the accused always has starts with a presumption of guilt, not a presumption of innocence. So I'm also the president of the Rule of Law Education Centre. So we've got to maintain the rule of law and the presumption of innocence.
We were talking about that. I was saying that earlier, that there's an adversarial system. The criminal justice system is based upon some fundamental common law presumptions about the duty to have a fair trial, right to silence. The statute in this state seems to keep chipping away at those propositions.
The effect of it.
And you've probably been a pioneer at times to make it more workable for societal expectations when you were a Crown prosecutor.
Yeah, especially for children.
Especially for children. And as you said earlier, you gave talks by explaining it all. You've now come to the defence side, and I think your most recent notable case that you did was Curtly Bill's case, where he was also accused and there was an acquittal there. So do you see in the cases that you do and your anecdotal experience that the Crown is, that where should the balance be? Should the balance be at a statute level or should it be at the DPP level? Because obviously in these 2 decisions that we've talked at length about earlier, both Judge Newlands and Judge Whitford both have made very strong comments that there is no discretion being applied to the cases that are being brought up. So is the statute a safe place to keep going, and should the policies be restricted at the policy level, the DPP? And you said there are all these change of command that you've got to deal with.
Yeah, that's right. Well, I don't think we should tamper any more with legislation, which really is the government putting its thumb on one of the scales of justice, and that shouldn't really be happening because it's hard to get it off. But the police too have to. It's got to start there. I don't agree with what is now happening in the police, where all the fact sheets say the victim, the victim, the victim, the victim. They used to say the complainant.
Yeah.
And so if police are writing this, they're subconsciously thinking, I don't have to do any investigations about this. I don't have to query anything that this victim has told me, because we believe victims, and I've already decided she's a victim. In the old days, they'd do a bit of a check. They wouldn't rush to accept that. She'd come in, and then they'd hold their horses until they checked a few things. But if we've got a complainant whose credibility is demonstrably problematic, is demonstrably lacking, because other witnesses say different things, the CCTV says different things, the phone calls say something different. What's the point of doing it? It's not helping the complainant to end up going through it all, and then there's a pretty obviously inevitable not guilty verdict. That just confuses her and makes her upset, and makes her think all this time she's been a victim.
The victim even suffers, even not to mention the accused.
God, yeah.
So my question is, do juries work?
But juries do work. Juries work better than one judge, and I say that with no disrespect to any judges at all. But 12 people have got a much better idea about life than one person. And crime is about life and about experiences, and about deciding who's telling the truth and who isn't. And so long as juries have not been, or members of juries, are poisoned by some ideological issue that's current, juries work really well.
Right.
But they don't work every time. Sometimes they get it wrong, and I've really seen that. And there wouldn't be a court of criminal appeal without that. But gee, they're good.
I just wanted to, I'm really interested in court technique. There's a whole bunch of stuff, because obviously I noticed style. You've got your own style in court. There's some fantastic exchanges you've had with witnesses in cases where there was one fellow who really sought to take you on. Which case was that? The name of
you don't narrow it down much.
No. You and he was sort of almost having this argument, and he was trying to say, "You can't say all this to me," and you can say, "Well, I certainly can, and I'm going to." And
Cunneen says, "Don't tell me what to do."
There's a tension there, isn't there? About they say at the bar course and everything. You don't argue with the witness. But also, you've got to try and keep control of the witness, isn't that? I mean, important in cross-examination.
You can't look like you're scared of them.
Yeah, exactly.
And that's happened a lot, because some of them are really bad guys.
Yeah, and they're saying, here's this,
female,
sorry to say, here's this woman sort of coming in and telling me that I've, putting these things to me. I'm not going to be walked over by this lady.
Yeah.
And you're there just polite as you like.
And bear in mind that there was a time when I was young too. And I'd have judges, like some of the old-fashioned male judges, really thought that women weren't probably up to cross-examining these.
You've got that pressure coming down from the bench as well.
So you've really got to show that you can.
didn't mind a bit of theatre back in the court too. There's the Kaleo case you mentioned, where that fellow, the allegation or the suggestion was that he had committed a crime out of greed, and he wore this Rolex watch quite ostentatiously. So when you were cross-examining him, were you, I think, you got one from somewhere or whatever, and had it high on your arm within your bar jacket, and then dropped your hand over and the Rolex slipped to the bottom of the thing. Is that something, if you think of those things, you think, well, a bit of theatre always helps?
Well, it worked because he couldn't take his eye off it. It was a really spangly gangster type one, gold with diamonds, and that I managed to borrow for the day, even though I had made a bit of a joke in front of the jury a bit earlier by tendering a photocopy of a black and white newspaper of a photograph of a Rolex watch, and the judge said, I can't see this. And I said, that's the closest a public servant ever gets to a Rolex watch.
Yeah, I love that.
But then I did the other. But
because humour's another thing they say, be careful with the use of humour. The courtroom's not the place for humour. But it sounds like, obviously, again, being the classic one to break convention or not feel bound by it at all, you used humour liberally, or when you thought...
Unfortunately, I'm very ready. I love laughing at things, and I can laugh at myself. And in fact, that's probably the funniest.
Can break the tension though, can't
It can.
sometimes as well?
That's right. Yeah, and funny things happen in
We're
courts.
particularly good at self-deprecating humour here.
Yeah, well, this is largely what it's about.
But also, when you're cross-examining someone and they get the better of you, and sometimes that'll happen and they'll answer something that was obvious and it's kind of funny, you've got to laugh because if you go, you show that you can't admit when you're wrong and you can't laugh at yourself. And the jury's watching, and the jury's not going to. Why is the jury going to go your way if they hate you?
Because good cross-examination, the people that I've seen, it's almost like a conversation, and there's a little bit of, you're also part sort of snake charmer. You're trying to get the cobra to dance out and do what you want it to do. It doesn't really want to because it's a snake and you're a human of it. Obviously, it's an accused and it doesn't want to tell you anything, or a witness doesn't want to tell you. So you've got to just sort of charm away and gently do it.
Talk about something related and see if
around. There's a real subtlety to it, isn't there? Do you find? How long did it take you to learn that, or did that something come to you intuitively? Do you have a moment where you thought, I kind of get it now, or do you just?
You can't. You just got to keep doing it.
What's the key?
You just got to keep. I don't know what it is, but just knowing, probably just being a conversationalist,
Curiosity,
talking to a lot of people. And
Curiosity is dangerous, I find.
Actually, you can go
for some reason, something came back to me that happened when I was very young with cross-examining a pedophile, and a young boy had said that he used to give him cans of corn to eat or something like this, and during the cross-examination he said, "Oh no," and I said, "You used to give corn?" "No, I'd never give him corn. I don't have corn. I've never had corn because I'm allergic to it." And an hour or two later, after we'd gone through this, and so you got up, you had your breakfast. "What did you have?" "Cornflakes." That's right. Because I was hoping he'd say that.
Oh, you really? Yeah. So it was an open question.
So I wanted to get around to breakfast.
It was an open question. But you knew what you wanted.
Have you ever used
used
the trick where you ask them about a question and you've got a sort of a document in your hand and it could be nothing to do with the case.
Of course I have.
And
and you're saying that you've never done, you're looking at your shopping list.
Guys, older, art forms, they're all part of the game.
But if I was to give, I don't know if I'm qualified to give tips yet, but I would have thought listening to the question is something that, listening to the answer, I find is something that...
I like to ask this question of all guests. I mean, we had Judge Stephen Walmsley here. Obviously, he's seen a number of cases and, had a number of experience to call upon, yourself, obviously, decades. What have you learned about humanity in doing what you've done all this time, seeing the worst of it? Are people intrinsically bad, or what do you...
Some people are.
You think
but
so?
Most people aren't.
So some people you think are just bad eggs? Really bad.
Just to show that I have, because some people say to me, "Oh, isn't that funny? Everyone was guilty when you were a prosecutor. Now they're all not guilty." Well, last year I did a trial. I was briefed in a rape case, sexual assault case, but it was from 1998, and I had one look at it, a DNA match. He did get convicted. And I didn't lose any sleep about it at all. In fact, I thought, great, the system really worked.
But the majority of people, you think there's a
bad,
context
just bad.
Some people are like that, but would you say the majority of people are they come to the criminal justice system because of what's happened to them in life, and if they're really informed by that?
A lot are, especially now when crimes have changed. Remember, we used to have a lot of the bad crooks used to do all the stuff, all the armed robbery. Well, you don't remember because I'm the oldest person in the room as usual. I'm the oldest elephant in the room. But the type of crimes changed. It used to be the 10% of people were the same, did all the crime. But now that it's a spread of everyone, it's much more that
Drugs
case.
have had a big influence.
Yes,
haven't they?
and because people can have lovely mums and dads, and something's just gone wrong for them.
Yeah.
And is that I only ask this question because to a lot of lay people, the first question that they ask is, how do you act for people who are bad? How do you act for them? Can you act for them if they're lying? There's the usual series of cliche
What if you know
questions.
they've done it?
What if you know they've done it? And obviously, we are keepers of the system rather than keepers of an individual, I suppose, is the answer I give. That's a very abstract concept, but I explain it. You know what I mean? Is that something? How would you deal with it?
Yeah, I'm often asked that, of course, and the answer is, well, if they tell you they've done it, then you can only represent them on a plea of guilty, and you'd have to say, if they still wanted to go to a trial, you'd have to tell them to go somewhere else. But even if you come to the view that they are guilty, well, someone has to represent people, and that's our system, and everyone deserves representation. And generally, the system will find them out, because a criminal trial is a great way to get to the truth, and I can't think of a better way.
Servant of justice really is what we are, of what you are, not of the, you obviously you serve the client, but ultimately justice is what you serve.
Yes.
Yeah. Margaret, it's been amazing. I'm just so delighted to have you on. I think the conversation for me has been absolutely fascinating.
I've enjoyed it too.
We appreciate your candour, your insight, everything. It's just been a fantastic time for us. So thank you so much for coming on the show, Margaret.
Thank you for being
great. I just wish you all the best with whatever else that you've got planned in the next little while. Maybe that retirement may never come, or maybe you'll keep going. But
I hope to keep going.
Yeah.
Thank you.
Thank you so much.
Thanks, Margaret. Awesome.
Thank you.
Okay. That's all we've got time for today, and thank you very much for joining us.
Next time, the Elephants speak with the Honourable James Allsop AC, former Chief Justice of the Federal Court of Australia, about the essential role of the right side of the brain in judicial decision-making, performance pressure, life, salient features, the universe and everything. It's an epic.